This is Jones & Co. Now, Alan Jones and Peter Credland.
Look, this time last week, media outlets were on fire over the guilty verdict in relation to Cardinal George Pell. I made no comment on this program because I had not read, as I would want to, sufficiently on the case. It was a unanimous jury decision of guilt. In proffering views in defence of Cardinal Pell, it should never be assumed that anything other than repugnance and abhorrence should be directed towards anyone guilty of child sexual abuse. Many would argue no punishment could be harsh enough. That said, we should also greet with abhorrence the prospect of anyone being in jail who's innocent. Or as Paul Kelly, the editor-at-large of the Australian newspaper, said at the weekend, the historic wrong done to victims cannot be atoned by the doing of another wrong. By convicting Pell, if such a conviction carries the enduring stain of a potential miscarriage of justice now and into the future, raising dark questions about our character as a country, our institutions and our legal system. Now, in the week since the suppression order was lifted and the Pell decision was made public, there have been what can only be described as very concerning reports about the evidence presented on behalf of Cardinal Pell, which was obviously rejected by the jury. By way of objective evaluation, certain points need to be made. The remaining victim alleged he was abused by Pell after a Sunday Mass in late 1996 and then again a month later. The point about 1996 is significant. It was established at the trial that Pell said only 2 solemn masses that year, but the cathedral had been under renovation, so it was not opened until November of the year the victim said the offences happened. Given that the complainant was adamant the offences occurred in that year, Pell's defence was able to establish that that was impossible. Then the offences allegedly occurred in the sacristy. This is the part of the church where the priest prepares for service, where the vestments and articles of worship are kept. Pell's legal team argued it would have been impossible to be in the sacristy, robed and alone, so quickly after Mass ended. Pell's Master of Ceremonies, the church figure designated to attend the Archbishop at all times, Monsignor George Pell, testified that the assaults could not have happened because, quote, I was with him the whole time he was robed on those days. There was also testimony that the sacristy was bustling after Mass with at least a dozen people coming in and out, tidying up and getting changed. Pell's lawyers argued that while Archbishop, he would never have been alone while robed at the cathedral. Monsignor Portelli's exact words in testimony were, quote, I recall the first 2 occasions he said Mass, and I can say I was with him the whole time. He was robed on those days. It was argued it would be impossible for Pell to molest 2 boys in the sacristy or corridor after Mass because of the number of potential witnesses in the area. The former sacristan Max Potter, who worked at the cathedral for decades, told the court he would unlock the sacristy in the minutes after Mass when altar servers would start returning to the room to disrobe. They would also clean up after Mass, meaning the sacristy was only ever momentarily unattended. In fact, Pell's legal team submitted that, quote, only a madman would attempt to rape boys in the sacristy immediately after the Mass. They argued dozens of people would be around, watching over the newly appointed Archbishop. The prosecution case argued that the 2 complainants were able to flee from a procession of choristers, altar servers and priests, leaving the church after Mass in order to make their way to the sacristy. Pell's lawyers argued it would be impossible for them to escape the carefully choreographed procession that was monitored with military-like precision without being noticed and reprimanded. Further, Pell's legal team argued even if they did, it would have been impossible for them to return to the choir rehearsal that immediately followed Mass without being noticed. No witness testified that they could ever remember a single occasion when a choir boy left the procession unexpectedly. It was alleged that Pell abused the boys while robed in his archbishop's attire, consisting of multi-layered dress worn over his natural clothing. The Jesuit priest Frank Brennan described the impossibility of Pell being able to produce an erect penis through his religious robes. One of the several layers of clothing is an alb, a long robe worn under a heavy chasuble. The alb is secured and set in place by a cincture, which is like a tightly drawn belt. And the alb cannot be unbuttoned or unzipped. An alb cannot be parted. It's like a seamless dress. But the complainant said that Pell had moved the vestments to one side, like pushing part of your clothing to the left or the right of your body to expose genitalia. But an alb, secured with a cincture, cannot be moved to the side. The jury was told there were no splits or openings in chasubles. Asked what would happen if someone needed to use the toilet wearing these robes, one expert witness told the court this couldn't happen. The living complainant testified that he and the other now deceased victim were caught drinking red wine in the sacristy. Pell's legal team argued that at that time only white wine was used at the cathedral. Pell's team argued that the complainant made up the wine reference based on Catholic tradition of using red wine during Mass. The silence of both boys in the years after the abuse was used by the defence as strong evidence that it never happened. Pell's lawyers argued that if both boys were abused, they surely would have at least discussed it amongst themselves. There was no evidence at the trial that they had discussed it with anybody. The living complainant swore he didn't discuss it with the deceased, and there was evidence that when asked by his mother, the deceased complainant denied being abused by the chorister. The president of the Victorian Bar, Matt Collins, said it was highly unusual for a conviction to be made on behalf of a victim who'd never reported abuse. He said no one can recall a case where an accused person was convicted of an offence against a deceased person of this kind. Dr. Collins said it would be an extraordinary situation to be convicted of a crime against a deceased person if there were no witnesses. George Pell's legal team may be arguing that the conviction should be overturned because of a fundamental irregularity in the trial process, in that Cardinal Pell was not arraigned, that is, the formal reading of a criminal charging document in the presence of the defendant. In response to arraignment, the defendant is expected to enter a plea. His defence team are arguing he was prevented from entering a not guilty plea in front of his jury. The appeal team are also relying on the dependence of the jury on only one victim's evidence. Of further interest is that the video footage played to jurors who convicted Pell marked the first time Cardinal Pell had heard the detailed complaints, which he passed off as products of fancy. Cardinal Pell declared, "What a load of absolute and disgraceful rubbish, completely false madness." Now, the remarkably gifted Sydney barrister Brett Walker SC will represent Cardinal Pell in the Court of Appeal when the appeal is heard later this year, probably in 7 months' time. It said that the decision to engage in new silk is standard practice in cases of this kind, and Pell's original team of lawyers who fought the criminal trial will remain to help free the Cardinal. Of course, there are those who say that jury verdicts must not be questioned, but appeals courts do that every day. And as I've said many times, the case of Lindy Chamberlain is the most famous wrongful conviction by a jury in Australia. As Miranda Devine wrote at the weekend, the point is, it's not without precedent that juries get it wrong. There is little research into the accuracy of jury verdicts in Australia. But a US study from Northwestern University found that as many as 1 in 8 juries gets it wrong, either by convicting an innocent person or acquitting a guilty one. A UK study found 2/3 of jurors failed to understand the judge's instructions. And a study by the New South Wales Bureau of Crime Statistics and Research found that in only 6 of 25 juries surveyed could all jurors correctly state their verdict afterwards. Miranda argued juries are not infallible. How the Pell jurors came to their verdict is a mystery, but they're not allowed to tell us. But in an age of transparency, it's archaic and unsettling not to know the reasons for such a momentous decision. Yet, as Miranda Devine wrote, all week, those who can't accept the guilty verdict have been vilified for daring to question the infallibility of the jury. But of course, appeals courts do that every day. It is there that the next chapter in the extraordinary story will be written. Well, we could talk about that all day, but Peter, look, we'll take a break. We've got some really interesting stuff coming up after the break, including the next 2 elections in New South Wales and Canberra. And can we be guaranteed as voters of a fair election? After the break.
This is Jones & Co. on Sky News Live.